So for some time, FinCEN had broken down the crypto space into users, administrators, and exchangers. And users, as the name would imply, were people who used cryptocurrency. And FinCEN had deemed users to never be acting as money service businesses, money transmitters. Administrators were the issuers of cryptocurrency, such as like an ICO company. And the previous pronouncement was they could be money service businesses. And then there were exchangers, which were always money service businesses. And exchangers were, as the name would again imply, crypto exchanges, things of that nature. Then in May, FinCEN refined its delineation and came up with, among other things, which I've talked about here before, but one thing I haven't really touched on is the impact of initial coin offering, initial exchange offering companies, and the intersection with money service business registration. And in May, FinCEN stated in no uncertain terms that if you were an ICO company or planning on doing an ICO, that the process, of exchanging value, right, whether it's fiat, Bitcoin, Ethereum, for a virtual currency or a convertible virtual currency, as FinCEN likes to call it, makes you a money service business, makes you a money transmitter, to be precise. And that being that money transmitter in turn requires money service business registration. So I believe, and I believe because the law says that I should believe it, that any company engaging in an ICO, IEO, or even STO really needs to register as a money service business. And we've been through kind of what that entails, right? The big thing is it's not that difficult to register as an MSB and become an MSB. Complying as an MSB can be difficult, right? You have to have a robust AML KYC program. You have to have training. You have to have an audit policy. You have to have all these policies in place that if you don't have, you're not complying with the law. It's sort of like incorporation, right? It's one thing to go to LegalZoom and get your company incorporated in Wyoming for $200, but that alone doesn't make you a corporation. Having bylaws, having initial minutes, all the corporate compliance documents that goes with it, that actually makes you a compliant corporation. So much like an MSB, the whole concept of registration means nothing if you don't follow it up with the actual letter of the law, which is this scheme of AML compliance. So, and the reality is, most ICOs are doing some level of AML, and that's a good thing that you really should do that because you have like OFAC issues, which you can never really get away from, right? Those are sort of mandatory. And then you have this modicum of KYC AML that you just have to do, right? That you have to do no matter what business you're even my business, that you have to sort of know who you're dealing with to some degree at least, right? The framework's different, obviously, when you're a money service business, but it's a real thing, right? And you have to do it. But not as difficult as you may think because you're not really dealing with cash. And a lot of the AML, SARS reporting, STR reporting, stuff like that deals with currency, like hard currency transactions, which you're not really going to encounter in any sort of ICO, IEO. So you have that. But the question becomes, and something I've fielded, FinCEN calls you a money transmitter, but are you a state money transmitter, right? And it's important to note that the definition at the federal level of money transmitter and the definition of your typical state, right, of which there's obviously 50 different definitions, or similar definitions at least, are different, right? The definition at the federal level is much broader. The definition at state level is typically confined to two concepts, right? Two different concepts. One is the acceptance of money. You may be a money transmitter if you accept money for purposes of transmitting said money, or you accept money for purposes of exchanging that money into some other value and transmitting that money. And so I would argue that state level money transmitter compliance is not tantamount to being a federal level money transmitter. So if you are doing an ICO, do you have to go around and get 50 money transmitter licenses to do it in the United States? My argument is no, because you have to be engaged in the business, right? And that term engaged in the business is found in almost each of the 50 states' definitions of money transmitter, of acting as a service provider that is in effect transmitting money for a fee, right? You're transmitting money or exchanging money to some other value for a fee, right? And I use money sort of going back and forth between convertible virtual currency, cryptocurrency, and dollars, right? But you're providing this transmission, think of Western Union, right? Or you're providing this exchange, think of Travelex, but you're doing it for a fee, right? You're providing a service. You're not in this, like as you would be in an ICO, accepting the investment and selling in turn some form of cryptocurrency, right? There's a very, very, very wide difference. Now, in the federal scheme, that exchange, right, that happens at the sale of an ICO token is enough to qualify you as a quote money transmitter. And you have to fit into these boxes. And you'll notice that if you ever go to register through BSA e-filing as a money service business, there's all these different qualifiers, right? Foreign exchange, money transmitter, seller of prepaid checks, different things that you have to fit into these boxes, right? But these boxes are way broader at the federal level than they are at the state level. So, to answer the question, I don't think it's necessary to register as a state or need to register as a state level money transmitter to conduct an ICO. I just think it's overbroad, and you're not acting as that service provider definition that all of these individual states sort of fall under, right? Now, if you're an exchange, okay, or you're just simply selling Bitcoin like in a Coinbase type model, then yeah, I think it's definitely necessary, right? Unless you're not dealing with fiat, right? If you're on sort of like the Bittrex model, then you really can get away with just being an MSB. But when you introduce fiat to it and you're an exchange or an exchanger, right, like what you'd be deemed in the federal scheme, on the state level, then it becomes different, right? Then you're really just providing that exchange service. You're not selling token as a quasi-investment, right? Or as in a utility token case, as sort of a use case, something like that. So, I don't think you have to go through it. The process of getting 50 state-level money transmitter licenses can be cumbersome. It can be, expensive. It costs you upwards of $100,000 when you factor in the bonding fees and things of that nature. But I don't think it's necessary, because I think, again, the money transmitter that FinCEN talks about is far broader than what state-level money transmitter licenses refer to. So if you have any questions, obviously hit me up as usual, comment or email me at Tracy firm, TRACY firm.com, and I will talk to you later. Thanks.